Counsel, you said what's important on compactness is where the core of the district is.
Well, it's not a question of compactness, Your Honor. It's a question of remedy. Does it remedy the violation that had been shown? This Court has never said that states are required to draw compact districts. There's no obligation to draw compact districts if they're not doing it for, if they're not drawing a non-compact district predominantly based on race without an adequate justification. So they can draw compact districts, non-compact districts as a remedy once a violation has been shown.
And you think the drawing of this district was not predominantly based on race?
I think
I mean, it runs from one side of the state, angling up to the other, picking up black populations as it goes along.
Well, Your Honor, that was the plaintiff's position, but as the state identified interests, communities of interest that it had joined in that district in that shape. And if you look at the Louisiana historians' amicus brief, they explain that it's not by chance that there are significant black populations in that corridor along the Red River. It's a result of history. It's a result of the history of slavery, of Jim Crow, and of the disparities that prevented the lack of economic opportunities that kept people there over generations. And so those ties are still there throughout the district. There are family ties, there are community ties, there are religious ties among those communities that are drawn together in that district. And that's part of what the state identified. What the legislature identified was the interests that they were drawing together in addition to the political reasons. So it's not a district that randomly draws together pockets of black
I think what the Chief is trying to get at is certainly politics played a role in this district, but didn't race?
Absolutely, Your Honor. The state was trying to draw a district that would remedy the violation that we had shown.
Which is another way of saying race predominated.
Well, I would disagree with that, Your Honor. I think that that means race was one consideration, and this Court has long said in case
I'm sorry. I'm sorry, Chief.
Go ahead.
Well, isn't saying race was one consideration another way of saying race predominated? And how do we square that with the 14th Amendment's promise that race should play no role in our laws?
Well, in the redistricting context, this Court has long recognized that legislators are always aware of race. And the fact that race was one thing they were considering when they drew the map does not mean it was the predominant thing. It means that it was one of many considerations that they had. Politics was another, communities of interest was another. And without some evidence that would disentangle those things and show that, well, actually race, among all of those considerations the state was considering, race was the one that actually drove the lines. Race the plaintiffs have not borne their burden to prove that racial predominance.
Thank you, Counsel.